You're live.
Morning, everyone, to House General and Housing. Today is Thursday, the 27th of February. We're going to be spending much of today going over and marking up.
Not working up.
Well, we're going to discuss pieces of the committee bill, latest draft of the committee bill. But we are going to hear briefly from Judge Zone, who is going to talk to us about appeals and his thoughts on the appeals issue. So go ahead, Judge Zone, and have a seat. We have, I think you know, members of the committee.
Well, good morning. I am Tom Zone, and I am the Chief Superior Judge. And so as Chief Superior Judge, I have administrative oversight for the courts. And I work with Terry Corsones, who you may know, the court administrator.
And her cookies.
And who does not know her cookie? Mrs. Fields has nothing on her. So I say that also because I am not in the environmental division as one of the presiding judges, and there's significant amount of subject matter expertise that the judges would have that if if you really want to get into some of those areas, I would have one of those judges talk to you. But the areas that we're here to talk about today are areas that deal with administrative aspects in many ways, as well as some subject matter. But I've spoken to the judges, I've reviewed the information, and I'm comfortable to be here today to speak to you about, I have in front of me, it's a draft 5.1, section 9, and it's a 4-page document.
Right, that's correct.
Okay. So on lines 16 through 19.
Just hold on just a
Can you
minute.
make sure, is it on a page?
This isn't on our page yet. This was the material that was sent to us yesterday afternoon by Ellen. Then could you just wait one
Of
moment?
course I can.
I'm going to send it to I'm going to send it to the committee and to you, so that we all have the same thing.
How did we survive before technology?
Very well. I think.
Back then, we would have said, can we go make a few copies of this?
Can you type it out?
I'm old enough to, my first internship, I used to have to transcribe the minutes from committees on a tape recorder.
I remember dictating
Yeah,
and having my secretary back in many years ago, I would have to do it.
very grateful for the changes.
Can you read shorthand?
I took shorthand.
Yeah.
Does anybody even know what that is?
Yes.
Yeah, my mom still.
I don't remember it at all.
It was still in shorthand.
Yeah.
Okay. I've sent everyone a copy of it, and it's gonna go in your emails, and it's gonna go on the webpage. Judge, perhaps you should just talk to Emily, and then by the time you get into the detail, people will have it.
Well, so generally, I understand there's concerns about the environmental division and appeals and how fast things are going. In 2024, there were, I believe, 28 appeals of housing, municipal housing matters. Of those, I'm sorry, 2024, there were 18 municipal appeals. 2023, there were 28. The average time to disposition in 2024 was, for the ones that have been resolved, more than half or more have been resolved, 123 days. In 2023, there were 28. The average time was 190 days. And that was also skewed, I would note, by several cases that were on the record municipal appeals that were extended for periods of time because they couldn't find someone, what we were talking about moments ago, to transcribe. the municipal proceedings. And so there were those delays.
Judge, just a quick question. When you're trying to do on the record and it's a recording, does the court request that the recording be reduced to a written transcript by a reporter?
I don't know the answer to that for practice. I do know that that's generally what occurs.
Yeah.
That's my understanding.
Okay.
But I don't know if it's the judge saying, I absolutely need this, or if it's the litigant saying, we're going to get you this. But I would think that the litigants want a copy of that because that gives them the baseline to be able to cite to specific pages. So I think I can't imagine a judge not saying they need that. The reason I point out these numbers is because when we look at what's happening, the reality is that cases are moving. The average clearance rate for over the past year in the environmental division has been 152%. What clearance rate represents is if you have 10 cases coming in, you have 10 cases going out, that's a 100% clearance rate. So the environmental division is disposing of more cases than are coming in. Things are moving in that court. We have a new judge, Judge McLean, who is there. You may recall that Judge Durkin had been ill and he had passed away after he left the judiciary last year. And so Judge McLean is there with Judge Walsh. Judge Walsh has been there, I believe, for 13 years. And when you look at what's happening in that court, the reality is that there's not significant delays that are happening now. I know I've read or heard about, well, there was this case that took 10 years. It was over 13 years ago. The judge is no longer around and hasn't happened since. And I can tell you here today very confidently, that will not happen again. We understand things that happened back then that can't happen. I don't know all the specifics of it, but I can say that under any circumstance, we have to make sure that that doesn't occur.
Do you have any opinion on the issue of whether, two questions. You said how many cases were there last year appealed?
In 2024, 18.
18. Do you know how many of those were appeals from a approval of a development as opposed to a denial? In other words, how many of the appeals really came from citizens who were unhappy with an approval,
I have a chart.
the so-called
That's a good
NIMBYs?
question.
I can't, I have the case docket names. Some of the docket names say site plan approval and some say denial, but I can't specify, I don't know for sure whether that is accurate as to how they work. So I don't know that off the top of my head.
Okay, and the second is how much of the time frame, the sort of 6-month time frame, I don't know if you can answer this, but how much of it is due to delays that because there's the council request a delay and then because they have too much of a workload or whatever? I don't mean your lawyers, I mean the lawyers for the developer, the lawyers for et cetera.
So if I can, then I'll jump around a little bit. If you go to page 2 of the draft.
Yeah.
Lines 16 through 19 talk about, except for cases the court considers of greater importance, and it has about taking the municipal cases take precedence over other cases and assign for hearing and trial accordingly. That question ties directly into why we don't need something like that, because that's what they already do. The judges prioritize every case. Every case is important. The Act 250 cases are extremely important. And keep in mind, of course, that there are times that a municipal planning case is with an Act 250 case because you need the Act 250 permit in order to subdivide to do the development. And so the judges prioritize those cases. The way it works is that if there were an appeal filed today, the court will schedule a status conference in a couple of weeks. The attorneys will show up at the status conference and they discuss the scheduling. How much time do you need to go forward? What do you want for discovery? And discovery is in a case. Discovery is where the parties exchange information and can do investigation. They can depose witnesses. They can send to the other side questions about what witnesses may say. They can get documents that might be relevant. They can find out what experts might say. And so discovery is something that is part of what we call the due process that the process provides. Because the developers want to make sure that they have all the information that they need to be able to pursue their permit. And the opponents want to make sure they have all the information that they need to be able to oppose the permits. And then the court gets to decide it. At that status conference, the parties discuss what's the timeline. Recently, I can tell you two examples, and I don't believe they were necessarily housing cases, but these are examples of how the judges handle the cases there. In one case, the issues seemed to be largely legal issues. And my understanding is that the attorney showed up at the status conference and said, well, we need 6 months. And the judge said, they're legal issues. What do you need 6 months for discovery for? And said, you're going to have 2 months. And so the judge carved it back. The attorneys, developer, let's say, and opponents were on board with an extended time, but the judge brought that back. And I'm aware of another case recently where the parties were seeking over 250 days for that process. And the judge said, that's too long. We're bringing it in. And so the court will oftentimes defer to the parties at that time to know, if you say you're going to need this much time, we'll go with that. But the judges just don't kick it out. The judges will bring it back and say, no, we need to move these cases because we understand that the timely and efficient decisions that come out of this division are critical for a number of individuals, whether it's housing, development, commercial properties, it's important. But what's critical for the attorneys is that they have the opportunity to get the information they need. And in answer to your question, Mr. Chair, I have not been made aware of any attorneys who were coming out of those meetings who were saying, I wanted the hearing right away and the judge is pushing this out. My understanding is that the vast majority, if not all, are by agreement. The parties will say, we need this much time, and the judge will either push back and say it's shorter, or the judge will say, okay, that's what you're telling me you need, and I'm going to respect that. The dilemma that we face, of course, is that sometimes things don't go the way the parties want. And so if they file a motion, that can take a little bit more time within the case if the parties file for summary judgment, and that's built in. But what is important to keep in mind is that when the case gets to the point after the discovery and the motions are done that they're ready for trial, we don't have a delay and we don't have an inability to deliver on trials. When the party's discovery is done, when the case is ripe for trial, the trial is scheduled. It is taken care of. And I would note that is in sharp contrast to what you may have heard about some of our other dockets. For instance, in the criminal docket, that is not occurring. Parties can say, we want a trial, but when you show up for the jury draw day, if you have 25 cases and you're down that list, you're not going to trial. That is not a dilemma that we are facing in the environmental division. My understanding is that every case that wants a trial gets a trial. And I asked a direct question. I said, if somebody showed up today, if there was an appeal filed today, and they showed up in 2 weeks for the discovery scheduling conference, and they said to the judge, we are ready for trial immediately. And it's a 2-day trial, let's say. How fast could that case come to trial? What I understand is the answer is 30 days. Within 30 days, they could hold that trial if the parties are ready for it. And so the prioritization, the court doesn't need statutes that say, well, you have to consider this of greater importance. And there may be policy reasons that the legislature concludes that's important, but we also have to look at impacts of those policy reasons. If you're a developer who is looking at putting in a building up in Chittenden County, that's going to be a commercial building, that's going to be, you already have a lease agreement, and you're going to bringing in a business with 150 people who are going to have jobs. And it's thereby stimulating and taxes, economy, and helping things. Do you really want the judges to say, we have a single family dwelling that came up for municipal appeal, you're going to have to wait on that? I would imagine no. And what message does that send to individuals? But that's a policy decision. But that's why the courts are prioritizing every case. Each case is unique, and the judges are making sure that when the cases are going forward, we're getting them in as soon as we can with the attorneys, giving them the chance to get ready. Are there stories about things take too long? Yes, we all hear them. But if there are any attorneys who have come to you and said, or any developers saying, we're ready for trial and that case isn't getting scheduled, please let me know. Because my understanding is that that is not what's occurring. But if it has happened or if it's happening currently, I want to know about it because we will make sure it's addressed. Within the past couple of years, for instance, when Judge Durkin was ill, I specially assigned other superior judges to assist. And so we do have that ability, but we don't have, as far as I understand, the need because Judges Walsh and McLean are keeping on top of things. And so we think that we're moving well. And again, the clearance rate of over 150% evidences that the cases are moving. If you look on page 1 of the draft, on lines 16 through 19, it does talk about essentially a legal standard for what needs to be considered. This does not add to current law because this is what they're doing anyway. And so is it necessary to add this type of language? No, because the burden falls on the appellant, the person challenging the decision, and the judges already do this. This is exactly what they do. Is it inconsistent? And so this is a provision that doesn't add anything. It's not necessary because that is already the law that's applied. The issue that is on page 3, section 10, standing. The question I would have is, what is the intent of the change? Is the intent to expand or contract those who can appeal? If the intent is to expand and allow more people to be able to appeal, this provision will accomplish that.
Will or will not?
It will. This expands. Because if you look at on lines 7 through 12, it says a person owning or occupying property in the immediate neighborhood of a property that is the subject of any decision or act taken under this chapter, and it adds an or, who can demonstrate a particularized interest in the criteria reviewed. Currently, there's no or. Currently, it's a comma. So what that means is someone has to both own or occupy in the immediate neighborhood of the property, and they have to demonstrate a physical or environmental.
Or.
No, or is being added.
Yes.
So by adding or, you're creating two separate classes of people who have standing. Whereas without the or, you have one class of people who have standing that have to meet two prongs.
But isn't number 4 an entire additional class?
Number 4 is an additional class.
Those people are being eliminated. In other words, the intent of the legislation, I'm not saying we've been successful. The intent was to narrow. And the reason was, right now, our understanding is that either you're in a butter, in which case you have a de facto right to appeal or nearby, or you're one of these everybody else who, everybody else, which is 4, the world can appeal.
So I understand.
We took out the world and said anyone who appeals has to have standing.
So what I'm saying is that if you look at number 3 in and of itself as a class of standing, that expands who can have standing.
Right.
If you are saying, and I understand what you're saying, that, well, that's the trade-off between number 4 and number 3. That's a policy decision. And if for instance, if number 4 goes away, if your changes to 4 don't go forward and your changes to 3 do go forward, you have expanded standing.
What we've done, as I understand it, I'm going to restate and ask me if this is right, because I suddenly realized maybe what was a drafting error. Right now, there are 2 classes of people. People owning or occupying property in the immediate neighborhood, that's in 3. 4 is everybody else. In 3, right now, if you own property in the immediate neighborhood of the property, of the subject property that's subject to dispute, you have 2 things you have to demonstrate, right?
Correct.
You have to demonstrate that, well, you do live nearby, and you have to demonstrate that you have a particularized interest in the property, right?
Currently, it's physical or environmental impact on your interest in the property.
Right, yeah, okay. So one approach, if we wanted to, would be to leave the language in 3 as is, and to substitute the language in 4 to say other people have to show they have a particularized interest.
So that is an approach. But keep in mind, if you make it an or, the people you're not just capturing the people who were formerly in or, if that's your intent.
Or, yeah,
You're not just capturing them if that's what you're trying to do. You're also making it easier for the people owning or occupying,
right,
because you're removing that second prong.
right. So if we left the language in 3, I'm not saying this is what's going to happen. If we left the language in 3 as it was originally before this amendment, and we added, we substituted for 4, instead of any 20 persons, blah, 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 we just put any person who can demonstrate a particularized interest in the property. It would narrow 4.
Well, 4 is already narrowed beyond what many believe. There was a decision rendered by Judge Walsh. It was in the Capitol Plaza subdivision case. And he discussed in that decision, the idea that just because it says the 20 people or the 10 people can come in at that time, can come into the case, that was one area of the ability to file the appeal, but he discussed how they still had to have constitutional standing.
Oh, he did?
Yes, and he adopted that. So in the environmental, that case was not appealed. And that's what you're basically talking about. And so what I would suggest, if you're looking in that direction, what it sounds like you're really trying to do is potentially codify what Judge Walsh came up with for a decision. So I can send you a copy of this decision. You can review it, but that is what he decided. He said that it was more than just X amount of people getting together, and that they actually had to show. Find the magic language, but he discusses it, talks about it.
Constitutional standing, meaning a particular.
Constitutional standing requires a particular injury
Yeah.
caused by the other party's conduct that is capable of redress by the court. And he said, here we are concerned with the first element. And he went through and discussed it. And he talked about they did not meet the criteria. And so I think if you look at this, again, the Supreme Court hasn't decided this. This case did not go up. There's been no appeal. So, but if you decided we want to codify that, that's a legislative decision. But it sounds like that's the direction you're looking at.
In that decision, would that mean that one person would have to have that particularized interest and 9 other join, or all 10?
I believe it was, he required everyone.
Right.
That's interesting, because I assume that's, Joe has uncovered in your response, an interesting issue.
Makes it much.
You mean, usually if one person has standing, that's enough. Did you mean everybody, Tom? That Judge Durkin felt all 10 had.
Judge Walsh.
Judge Walsh, that all 10 had that standing,
My recollection is he required it for everyone.
right?
Hmm.
Interesting,
I
okay.
like that.
That does narrow it down.
That does.
I do like that, yeah.
It's called associational standing, that's the question. And he decided that too.
Because the court finds that parties appealing
Yeah, right. We
as a group of 10 must satisfy both statutory and constitutional requirements, we turn to the question of appellant's constitutional standing in the case.
Does that case, that given that it wasn't appealed, does it have any precedential impact in that court?
Judge Walsh is the judge who issued this decision.
Right,
And so that is how he sees the law.
yeah,
And my understanding is that Judge McLean, this occurred prior to Judge McLean being on the bench. And he was actually the attorney who advanced that theory before the judge on behalf of the city.
His judgment.
I cannot speak or opine as to how he would see it in the future, but
And this was in 2020.
this was 2019.
So that's not the McLean who's a town attorney. Okay. Thank you. Any last questions, Judge?
No, I'm. There's a situation in that municipality that this might have changed, but my wheels are turning, but I don't have a question.
Good, I can see the wheels.
I see the wheels.
Yes, Debbie.
I was just concerned about the number of people. I mean, you may not have that many people in the neighborhood that,
Well,
I mean, can you do less? I mean,
Oh, well, it depends what we do, but in the current, the current draft that the committee has that I just sent you just eliminates the 20 people. It just doesn't deal with that. It just says nobody can sue unless they can show standing. In some ways, it's narrower,
so
but although subject to the problem which Judge Zone has uncovered, which we could correct if we wanted to.
That makes it much more narrow with 20 people, 10 or 20 people, it has to affect.
That would be very narrow. Yeah, that would mean that you'd have to find 10, let's
20 is
use
even
the
harder.
example, let's use the example that Elizabeth brought up yesterday. Supposing that there's a big runoff into a stream problem. So under the standing requirement, let's say that you don't live near the stream and you don't drink the water and you don't swim in it, but you believe as an environmentalist, say, that any development shouldn't have that kind of runoff. If you just impose a standing requirement, the effect of it is, I think, it just goes to nobody under a traditional standing requirement could possibly appeal that decision. What they would, unless they could demonstrate that they swim in and drink it or adjacent to the stream or otherwise harmed by that runoff. If you were just the environmentalist that I described, your role would be to go to the hearing and make your point before the legislative body, which would have to decide as a policy matter, were they going to approve this development or not? In other words, that's where you'd make your point. The standing requirement is about who can then challenge the decision and sue, and they'd have to show that they had been particularly harmed. The 20-person, the way the 20-person is written as opposed to the way Judge Walsh said it, it just says any 20 people. You could be one of those 20 people who just don't like it.
Mhm.
But what Judge Walsh did, which is kind of interesting, is he, as a judge-made law matter, common law matter, he said, I interpret 4 as to actually require what we've been talking about.
And he also discussed organizational standing,
Yeah.
I believe in one of his footnotes. So he
Yeah, so he-
addresses each of those
He
issues.
says everybody who appeals has, so what that would mean is not only would one person have to show that they lived adjacent to the creek or whatever, or drank the water, I don't know, swim in it, whatever, but everybody would. And so that's pretty heavy. Yeah,
And again, I note that it's a decision by one of the judges, whether the other judge sees the law the same way. I don't know that he's ruled on it yet, and whether if there was an appeal, the Supreme Court would concur with that analysis is another question. But certainly it's the law that Judge Walsh has been applying.
so if we codify that, it eliminates the not knowing.
Correct.
Judge Zone, thank you so much.
Thank
This
you
has
very
been
much.
Really,
Very
really,
helpful.
very helpful to us.
And I will send you a copy of this decision.
All right.
Thank you. Have a great day.
You too.
You too.
So at this point, golly, we don't have additional testimony at this point, do we? Right, so we have discussion, so maybe we should start walking through the bill.
Yes.
Coach,
Does everybody have,
Mark,
yes,
I've got a question. Are we
Yeah.
planning to hear testimony from somebody from JFO about the impact of the retail sales tax?
We haven't scheduled anything.
Okay,
The sales tax, in other words, are you talking about the provision of the bill that eliminates the sales tax on construction materials for housing projects?
yes, I thought we were going to hear from somebody from JFO about the impact of that on the ed fund.
The amount.
Mhm.
Yep.
What's the sense of the committee on that? Would you like to hear from JFO on that?
Absolutely.
Yeah.
Okay. So we need some, thank you. So
Thank you.
what I was gonna, thank you, Elizabeth. Um, what I was going to propose, first of all, does everybody have draft 4.1 in front of them? Yep. Okay, so please depend. Okay,
Pen?
all right,
I have to check the mark.
okay.
I just have to go grab something. Sorry, I'm 2 seconds. What section is that for regulated?
The sales tax one, it's actually not even in here. It's just on
Yeah.
page 15, just a placeholder at the moment.
Yeah, we still are gonna have. I think we're gonna probably be having committee bill versions 5, 6, 7 until Friday, when we do a straw poll.
Tomorrow.
Yeah, that's tomorrow, right? Hey, all the time in the world. All right. The first, I was proposing, if it's okay with the committee, to go in order. That's just go through it in order. And one of the things we can do is we can get help from the relevant attorney, but only if we have questions, and they should be specific. I mean, ideally, to save time, and Golly, I appreciate your thoughts on this, to save time, what we would do is submit to the attorney a list of questions if we have them, so they would be prepared, come in and answer the questions, and we could close out the discussion, if any. Right? Okay, so the first section is VHIP. And remember, what matters is the total underlined portion or select portion are the real changes. The yellow just refers to the difference between this draft and the prior draft. So if you want to know, well, how are we changing the law overall? Look at the underline. So thoughts about the VHIP program, which is this, and then the appropriations, it's this section, this whole section, and which goes on until page 5. And it also has an appropriation of, it's in the governor's budget now, and we repeated it in our letter to approach of 4 million plus, I think, on FTE. Is that right? Well, it's
Yeah.
plus 1. Yeah, I think so. So, thoughts?
So I have thoughts.
Yes.
I'm obviously very supportive of VHIP. I've always been very supportive of VHIP. Do we want to talk about the proposed language from Commissioner Farrell on VHIP? Or do we want to, no, I believe we're trying to get Sean in here today too.
So let's, want to explain to
Yeah.
the others what we're talking about.
So Chairman Hawley had asked DHCD to help us come to a compromise because in the administration's plan or proposal, they removed the need for I believe for both 5 and 10 year to help people exiting homelessness. So last year, I believe upstairs in Human Services had put that stipulation in. And so we're trying to come up with a compromise. And my understanding of did we send this to everybody?
The email, Oh, gosh, did I send Alex's email to
I
everyone?
don't think so.
Magali, you have it, don't you?
Yeah.
Could you send it to everybody? But that's, everybody should have that, but go on.
So, just so you have it. So there's a clear, so it's not, from my understanding, it's their recommendation would be setting aside part of the money that will go to people who are exiting homelessness. So right now, I don't think it's necessarily working, making sure that it's serving everybody who's exiting homelessness. And so it's kind of a happy medium where money is still set aside for those people.
I want to ask a question of you, actually. My understanding was that there are two programs. There's the 5-year program. By
Correct.
5-year, it means you have to agree to 5 years of HUD market rate.
Correct.
And then there's this newer 10-year program, which is 10 years at HUD market rate. The difference, as I understood it, in existing law is that the 5-year program has in it a requirement that you give priority to people exiting homelessness.
Correct.
And the 10-year originally, as proposed originally by ACD, was not to have that requirement. In other words, you didn't have to serve people exiting homelessness, true, but in return, you had a 10-year.
Yes,
10-year
correct. I
program.
misspoke. Thank you.
Yeah. But then what happened is that this body, through Human Services, took the homelessness requirements and put them back in for the 10-year program
Last year.
last year. This administration proposal strikes that again. In other words, strikes out for the 10-year program, the requirement that you
Okay.
take homelessness on. Human Services position, to the extent that I know it, I mean, Teresa, should speak for herself, but I'm pretty sure, is that we're seeing increasing, the number of homeless is going up and up and up. And a lot of them are coming through evictions, et cetera, whatever the reason, we're just seeing more and more. And that we can't just, if we have a whole VIA without any homelessness requirement, then everybody will dump the 5-year and go to the 10-year. And in fact, okay, I'm not even going to predict whether that would happen, but it's the concern. So as a result, I asked Commissioner Farrell if he would please think about this and think about whether there wasn't a compromise. He is going to come at 2:00 today and present his compromise. And so what I would urge for this discussion purposes is that we ask ourselves, is there anything else in VIA that we would like to change? Or are we okay with the rest of it and hold until 2:00 and after discussion of what we're going to do about this one remaining issue?
Also, sorry, it's 1:30.
1:30, okay.
Yeah, I'd like to wait till they're here. I'd also say that I think that initial 5-year, 10-year split with the 5-year requiring priority to homelessness was the compromise. Compromise.
Yeah, but then, yes, okay, it changed here. Yeah, Debbie?
I don't know if it matters, but I was just wondering if somebody like bought a building and they wanted to participate in this program, how long does it take to get on board for this program?
Pretty quick when they have money.
They have to.
They had to do matching funds.
They have to have enough money to do, without grant or loan, let's not get into that. They have to contribute some of the money.
Right.
What, do you happen to remember the percentage?
Well, there is
No.
somebody in this room who I think could probably speak to it a little bit
Chris, you
more.
want to give or who is it?
Chris Donnelly, Champlain Housing Trust, I believe it's 10%.
10%. No, who gives what?
the grant comes in and I believe the landlord, the owner of the property
Yeah.
needs to match by at least 10%.
Which the current program, everyone's matching by about 100.
And then there's much more match that's coming in right now from the property owners than that.
Is that because the properties, because of the $70,000 limit isn't enough, and so people are just throwing in their own
Some of
money?
them there's $30,000 limits, and then there's $50,000 limit and, you know, cost of materials and labor and so forth.
But how much time does it take to?
So it depends
go
on,
through that
it depends on the resources. There's underwriting that gets done.
Yeah.
So there's a process. It's, I'm not sure exactly. I can tell you when, but it's also building.
So it's not like a year?
It's not a year, I mean, right now it's not a year wait.
Okay.
I think also something to be aware of, and Cameron has talked about it a lot, is that in past, it's been in session law. This would be making it statutory. And this program has always been incredibly oversubscribed. They are constant, have a wait list miles long. So I think it's important that we recognize that, and I think that also probably lead times go into that as well.
Let's talk about this a little more. One of the things the administration is doing in their proposal is taking VHIP, if you will, and formalizing it more by making it a statutory creation as opposed to in session law. The other part of it, which is important, is is not up to this committee. And in fact, we didn't opine on it in our letter. In the there's two kinds of appropriations, one time and base. Base is always harder. It's just harder to get base. There's less of it. The Appropriations Committee has to be very parsimonious when it comes to base. The administration's budget has the $4 million in base. And I don't know whether the Appropriations Committee will do that. If they don't do it and we do this and they approve of it and it becomes law, it just means every year they're going to have to come back it'll be a little more of a fight for them to get their money. But that's not up to us. And because I couldn't deal with it and thought it would be beyond our bandwidth, I didn't put whether it's in base or one time in our list. I just put the amount because they're going to decide that. You had a question or a thought?
What would a compromise look like? What's an example of what a compromise?
I think they're compromised. I haven't had time to read the whole email, but I think it's basically saying, let's start off with a certain percent has to go into homelessness. And then let's have a process going forward for figuring out what that is. I think that's what Alex is going to tell us. But I don't want to put words, or Sean, I don't want to put words in his mouth. I do have a question. And I guess I would appreciate, Chris, any comment you might have, well, anybody. The draft with the 5-year program struck out forgivable loans and just stays with grants. And I seem to remember in testimony, the reason being simply, we've never made a loan. We always do grants. I'm a little worried. Well, first of all, I'm a little worried that in the future, with the 5-year program, a developer would want, I would think, they would want the loan, not the grant, because they don't want to pay taxes on it. And I think it would be harmless just to leave the language the way it is. I mean, in other words, I don't feel that they're never going to do it. They're never going to do it. Chris, do you see that about this?
I do, and the department should clarify some of their reasoning for this.
We can ask him.
My recollection is that the source of funds originally for this program was the ARPA, American Rescue Plan Act.
That's right. You had to
And
give
so
them
when
away.
that came in, if the funds were used as a loan, and the loan period was longer than the time that it took to expend all the funds, then there was a risk of recapture from the federal government. So those funds were made as a grant in order to spend them so that they would not be at risk of being recaptured.
And that's not the case
And
anymore.
that's not the case anymore. These are general funds now, so I'm not sure if there's another reason why. There's a preference not to have the loans involved. But I hear what you say, Chair, that perhaps the property owner would like that option.
So I think if it's okay with the committee, I'm gonna hold my comment on this until we have a chance to ask Sean whether there's any reason we couldn't just leave the language the way it originally was.
So then I would suggest we move on to the next section.
Okay, but is
Wait.
there any other comment on the,
I have a comment on VHIP. I guess one clarifying question that we could ask is, who is this for? Because my understanding was that the original VHIP was for small property owners, not for developers. And so if we could get clarification on who it's supposed to be targeted towards. I've had it in my mind that it's for small mom and pop property owners to be able to, I mean, I thought it was to, not for development, but to get small properties back online. And if that's the case, then why wouldn't we consider loans versus grants? Because loans are easier for small property owners than reimbursement grants are.
well, we certainly can ask. I don't know. Chris, is there any history you have? You guys administer this for your area. Is it small developers generally?
There's a range of owners in the portfolios that they manage in this program.
So it's both small
It's
and
both small and larger property owners.
that happen to have a lot of commercial property. I mean, a lot of properties, residential property.
The range.
But I think so I have three questions for Sean then. Who is this for? Loan versus grant, and of course, the big one, the compromise. Any other thoughts? Otherwise, are people comfortable with this? We're not doing a straw poll on this, but just want to know if people are comfortable with it. Claudia, Elizabeth, assuming we get your question answered, how do you guys feel generally about the VHIP section?
I was always good with VHIP. I'm gonna wait to hear at 2 o'clock what the compromise is. And then my only concern was also the loan versus the grants. I mean, I prefer to keep both in there so that folks can have options. But outside of that, I think the conversation has gone away we thought it would. So I think it was fine. I didn't think there was much to be changed in there.
Elizabeth, anything else?
Well, I think that finding out who this is actually for and whether its original mission has changed makes a huge difference to me.
Yeah, I can probably speak to that a bit.
Go ahead.
Yeah, you're right. The initial project was kind of get properties that weren't up to code and things like that, or people were living in and still weren't up to code, and give landlords the opportunity to use the program was the initial goal of it. And then it moved to ADUs, kind of as you get the low hanging fruit, expand it so that you can hit more units, and then it expanded to new construction of units. And yeah, so it certainly started out, I remember the first year being more of a trying to get those units that were taken offline simply for health code violations or things like that. But
It was.
And so as such, I think that part of the reason that there was such a great uptake in the original, not just because it was ARPA money, but because there are so many apartments and units that needs, $50,000 worth of, or $100,000 worth of rehab. And I don't believe that the ARPA funds covered all of that. I am certainly not opposed to adding ADUs or attached apartments, I think that's also another great way of expanding small, small amounts of housing. But I don't know that I agree that this is the best place to add in funding for developers. And I worry that it takes away from the, because I don't think the work is done in those smaller capacities. I worry that the smaller units are not prioritized over the bigger developers.
I think an interesting question, I just would only add to what Joe said, that I think I think originally the program was kind of a response to COVID and the homelessness that was happening, thus the 5-year program.
Exactly.
Yeah,
Exactly.
well, but I just want to say, in all fairness, I don't think personally it's a bad thing for a program to evolve. The question is, what does it evolve to? And I don't know, and I guess, Chris, I'd ask you, do you have any opinion as to the amount of money that's here involved as a it inserts into this project is $50,000 or less, and except in case of if you're doing accessibility, it's 50,000 or less. So it's small amounts of money being injected in the project. Are most of these still, whoever the developer is, whether it's a ma and pa or a large organization, are most of the projects still individual units that exist as opposed to helping people build large numbers of new units?
As you said, the program is evolving. I don't think it's large numbers of units. I think those small number of units, if there being new ones being created or being added. I will say for all of you that the department keeps a list of all the grantees on their website and what they received and where they are. So I think you can find it on their website, or I'll look for it, I can send it to you. But it'll give the grantee in the town or the borrower in the town. So you can see for yourself who these people are. Or organizations is important in some instances.
All right, can we go on to the next section? Or did you
I
come?
just wanted to point out, I'm just glancing at a couple of the websites and it looks to me like it is the property owner who applies for VHIP. So it still covers, it's not necessarily the contractor or property owner. Landlords could have 100 units, I suppose, but it's the property owner.
I think we've got our issues on the table. I have 3 that we might ask Sean, who's this for? Small versus large, loan versus grant, and the compromise. Okay. So the next is the Manufactured Home Improvement and Repair Program. This is the program that allows, and again, but it exists in session law. And this essentially takes, my understanding is this doesn't change the program from session law, materially. What it does is it says it's a vehicle that, again, you need appropriations for, and there is an appropriation which we put on our letter. And it basically says that you can do several things to help mobile home owners and parks. One is you can invest money in the mobile home park by helping them to have better infrastructure. More water, sewer, whatever. Access. I mean, there are mobile home parks where when you drive there, you think, oh my God, I'm gonna sink into the mud, And the second is it gives people the option, it allows DHCD to help individual owners of mobile home themselves repair or improve their homes. And the third is it allows them to give money for slabs, foundations, so that they're better foundations. And so I'm wondering how people feel about this.
I like the program. My only question is, does this change anything about how the program is run right now?
My understanding is no.
Okay, perfect.
I mean, I think that's the
That
testimony.
would be the only questions I'd have after the answer is yes.
Okay, so it moves it from session law to.
Right.
statutes.
It still has to be funded.
Right.
How do you feel, Ms. Expert?
I think that this program is a great program. My only confusion is that having to do with the foundation, which can be $16,000 to $20,000. The co-op, the park, can ask for that as well, but so can the homeowner.
That's
The
right.
homeowner doesn't own the property. So I don't know how that really works because homeowner doesn't own the property. But if they need the slab because they're getting a new home, they don't get to keep that slab. That really goes with the,
Yeah.
with the park.
Community.
So I don't know which one is easier to be able to ascertain. It's usually when someone has a home that has become inhabitable from water damage.
Right. This is a grant to the
Both.
homeowner, right?
Both.
Where is it?
The 20,000 can go to the owner of the park and the 15 goes to the
Complete small
homeowner.
scale capital needs. And presumably, well, it doesn't list the,
Does not list that. It lists it under the 15,000.
it
to the
lists
homeowner.
15,000, and that's to the homeowner.
See, I would just like to know if there's any way where with, like, the example I gave, that somebody has water damage and then it becomes inhabitable, is there a way to make it expedite it so that it doesn't get caught up in that loop of who's applying for it and getting the assistance for it versus the homeowner or the park themselves?
Well, what it seems to me, I'm just gonna put this out there and we can ask Sean about it. Well, is it Sean, do you think, or is it Alex?
Sean,
Sean,
would be Arthur Hamlin. But you're.
but he retired.
well, we can ask Sean, but right now, it says that the department, I'm looking at their general ability to grant 20,000 to owners of the community to complete small scale capital needs, including,
But not limited to.
but it doesn't say, but we could say, but not limited to.
I mean, lot grading and preparation
Yeah,
at the slab.
yeah, that. So I think they could get the grant. I think they could give it to either.
Okay.
I think having, sorry. go for it.
Just a wider question that we won't have time to deal with between now and Friday, but maybe when the Senate bill gets here or whatever. I still look at these numbers and am wondering if a grant of $20,000 to the owner of a manufactured housing community is worth $20,000 to them, or whether they're going to be paying income tax on that and they're only going to get $10,000 worth of work done. And it just seems like maybe before everybody starts panicking about their income taxes, we ought to get a tax preparer or a tax expert in here to answer that question.
Typically, there isn't taxes to these.
Well,
It's
Isn't there a,
Really?
well, if it's a
just what I'm
co-op,
wondering.
it doesn't pay, does a co-op pay?
Co-op would be not profit.
No,
It's not a profit.
it's a form of nonprofit.
Yeah, it's not like a five oh one three
It
C.
doesn't pay taxes.
Okay, so that would be.
But
different
a
than-
private owner is a corporation and they pay taxes.
Right, and the homeowner is not nonprofit.
But the homeowner, yeah, the homeowner might be stuck with taxes.
Some, I guess.
We could add grant or loan.
Well, so it would be- Yeah,
I,
Why would grant a loan change anything?
Because that way they could loan the money.
Forgivable.
Yeah. Or they could loan it like 0% interest for, there's lots of ways you can structure a loan. Okay, I think we have to ask.
Circle back to.
Yeah. Okay, May, actually, just a second, let me write that down. You guys,
think for the 15,000 going to the homeowner might also. Foundation, approval side. They can also within, oh, never mind,
What are you thinking?
within a manufactured home community. I was thinking maybe that would cover somebody who has a mobile home, not in a mobile home community.
Say that again?
Somebody who has a mobile home, but not in a mobile park community.
Oh, okay.
But at the bottom, it does say within.
Yeah, I don't think that's the whole thing with the registry.
It is.
If it's not registered, if you're not in a park and on the registry,
Yeah.
you may not be
You don't get any of this. Yep.
eligible, was the word I was looking for in my clogged brain.
Okay. I think,
Okay.
I'm just adding a question, grant or loan, any other questions you might have? Do we want to, or do you think these amounts are okay? Or do we want to increase them? I mean, it wouldn't increase their budget. I mean, they're still gonna have to live within their budget. I'm just gonna ask him.
Yeah. I don't have any.
Okay. All right, now we're on to the Vermont, and may I move on? What I'm hearing is, subject to a little refinement question, a few questions. People are basically okay with this, with creating this in statute. Okay. Now we get to the Infrastructure Sustainability Fund. Remember, this is essentially, it's one of the devices that we have. In fact, the only one that's in this committee as opposed to Commerce, to really get at the problem of how do you develop infrastructure in a way that does not overly burden the development itself, such as with the effect that it raises prices in the development. Whether that's a nonprofit developer or a for-profit developer. Because remember, as a practical matter, the developer doesn't pay, the development has to pay. And so when you get funds from the outside, like tax credit money, it's just, free money, and that really helps buy down the cost. So this was the creation. This idea is, I think it really came from the bond bank. And as I understand it, and I'm just restating it, there's an appropriation in the governor's budget of 9.1 million. I put 15 million, just we thought it could use more money. We're on page 7. We've got I'm going to reprise for you. We have some questions for Sean when it comes about VHIP. We have some questions, a few about the mobile home park, but just a few.
The MER.
The MER, yeah. And I'll go over them with you when there's a minute, but Sean is coming to testify here at 1:30.
Okay.
Okay,
Yeah, sorry about that.
okay. So we're in the infrastructure fund. It's kind of the way he sees it, the way the president or executive director of the bond bank sees it is they could use the money that's allocated several ways, all towards infrastructure, any infrastructure that's necessary for a development. One is they can just loan it out at like 2%, which is a lot less than the current commercial rate. Another is that he could operate like a green bank operates, really trying to leverage the money using other resources. One way he could do it is use his own resources. He has a fund that they get by selling bonds every year on the open market. That's 7% money, or whatever the market says they're going to pay, they're going to charge for tax-free funding. It could be 5%, it could be 4%, it could be, it just depends on the interest rate environment. He would use the 9 or 15 million, whatever it ends up being, selectively to buy down the interest rate. He would use the capital from his own fund, but he would use the 9 or 15 million dollars to buy down the interest rate so that it would be lower. It wouldn't be as low as 2, but it would be lower. Then there are other more interesting kind of esoteric ways of using money to leverage it. Say there's a lender outside, Northfield Savings is willing to lend money, but they need some backup. They need to know that this is guaranteed so they could use the money to issue a guarantee. Another would be, there's all kinds of sort of extra charges when you get a loan. You have something, for example, called loan loss reserve. You have to set aside a certain amount, and so that there's enough, you borrow enough money so that if you have trouble paying at any point, there's like 3 months payment set aside. There's all kinds of other stuff, all of which the bond bank could use this money to take care of. And that those credit enhancements are ways that you can take money and stretch it by using private money. And that's what this is. The language from the administration's proposal as modified. There's one outstanding question that Cameron indicated he wanted to know on page 9. What is the Vermont Community Index? And we don't know. Do you know what?
I know roughly what it is. I found a couple of years ago in deciding how to steer in ARPA funds, the administration came up with a series of criteria to assess the capacity of local communities to manage money, or what, and also layered in some equity, concerns. And so there was a whole ranking and rating of municipalities and a scoring,
Right.
How to prioritize. So I can try to find that index.
You don't have to.
Okay.
Okay, I have a comment on this if I might.
I do too, but.
Okay. But this was, I went through this when we were in appropriations. This was the Department of, I can't remember which department it was. Who, do you remember, Chris, who administered? It was Doug Farnham. Yeah, it was $2 million to help towns apply for money. Towns were losing out on grants because they didn't, and particularly the federal ARPA grants. Remember, this is when we had federal money raining down on us. So the idea was $2 million were appropriated, and various people could bid on helping towns, the RPCs, others helping towns apply for. In order to create a ranking, Doug Farnham's operation created some actual computer-driven analysis of towns' capabilities and ranked them. And I actually witnessed the result of the ranking. I will say it is, in my personal opinion, mediocre. It wasn't awful. It just wasn't, it was, it's like any other computer generated thing. It ranked communities high that I know in my district are brilliant at getting grants. And it ranked communities lower that had no capability of getting grants. What doesn't bother me about this is that it's just one of 5 things that they have to take into account. It's not, despite the fact that I think it's sort of, and they're changing it all the time and trying to make it better. I don't mind it being in there. If anybody has strong feelings about it, we could strike it. But do you, Chris, have any opinion?
I do.
Yes. Are you willing to tell us?
Yeah, I think I think the methodology is a little flawed.
Yeah.
And especially since I've seen it applied to, or attempt to be applied to some housing program and some other community development programs. And essentially, in where I am in Chittenden County, all the Chittenden County communities ranked in the lowest 25 percentile. And so there's no access to, if the criteria is used in such a way, there's no access to any funds to the county, and maybe, and I think that was part of some of the purpose.
Yeah,
And that's
because they were good at it.
legitimately.
Yeah.
But I just think you should think about how it's being used before layering it in. And infrastructure may be one of these places where it might be a good index to use. I just think it needs to be just thoughtful. I just know that there was another grant program that dealt with libraries that it didn't make any sense to layer this index
Right,
into
so
the criteria in the amount that it was. So
I would say right now, being that I feel like we don't have a lot of extra time, we either leave it in or take it on the grounds that whoever's running this program, they've got 5 things to think about. This would be one of them, or we just take it out. And if the committee has any opinion on that, I'd like to hear it. Because we're just gonna go one way or the other. Yeah,
I would suggest that we take it out. I think. One, again, reiterating, we don't have time to hear more testimony. But also I think we've heard from almost everybody who's come to testify before us that everything is so difficult. There's so many hoops to jump through that making a process more simplified would probably behoove our entire process of building in this state.
other opinion,
Yeah,
yeah.
I'm guessing, are you speaking of the MTAP program? The Municipal Technical.
Yes,
Program?
yeah,
That's
that
what we're
one.
talking about.
Yeah, that, it
I'm
was
just
used,
talking about the index.
the index was
Created,
used
figure
to
out.
develop.
Right,
Who's
but now,
eligible.
now the index has been used to
For
add
others.
other kind of
Yeah,
criteria.
yeah,
I
yeah.
think this is nuanced when you're talking about other programs.
That was what you're.
But it was,
So-
I think it was originally for
For-
that program, yeah.
Okay.
That tell you whether you like it or not?
No, it doesn't at all tell me whether I like it or not. I just know I have. If we take it out, we have no other criteria as if that were to be, if we wanted to steer it in a direction, I don't have any other criteria to replace it with, good or
Other
bad.
than 1, 2,
Well,
Yeah,
other,
five.
yeah, as far as capacity, municipal capacity to go up with this money, right? Like,
Yeah.
like you said, it's certainly flawed, but I also think it is
Does
important.
its, sorry,
oh,
does its inclusion here make a communities lower down on the index? Does its inclusion here trigger the technical assistance, make them eligible for it? That's
separate.
elsewhere, so they pursue that elsewhere.
Right.
So whether or not, so they can be low on the index and have tremendous
need.
need and tremendous technical assistance. They might.
Yeah, I mean, there are, I kind of feel like
It's superfluous.
that it's super, it has here project readiness, estimated time until the need for the finance, demonstration of financing is complete, there's already pretty strict criteria. I guess I'd go with you.
Yeah.
I also think, did Commissioner Farrell say he was going to accompany Sean today?
Yeah, I think we should ask him.
This might be, I just have it marked for something to ask, so hopefully we can get a bit more
Alright.
information.
Okay,
Let's ask Carol. I don't see anything else that addresses the capacity of the municipality.
it was entirely based on what the system was designed to answer the questions. If we want to state communities in terms of how much they need extra help in applying for grants. In other words, the neediest ones were the top, the least neediest were the bottom, which is why Chittenden County was always at the bottom because they have capability. So it was trying to show how badly off you were in terms of the ability to seek grants. And I'm not sure I don't know if that's relevant. I'm not sure. But it was inaccurate in addition.
Okay,
So I'm gonna ask Carol about page 9(4), the index. So anyway, any other thoughts on the infrastructure sustainability fund? How do people feel about it?
I love it.
You love it. Good.
She loves it.
Others, how do you feel about it? Saudia, Elizabeth? You're in the room.
It's fine. I have other questions, but I want to get through this because I don't want to derail the conversation. So what I'm doing is I'm just trying to frame my thoughts so that the question doesn't get answered later on. That way I can let's just get through it and then I have a question, but I don't want to ask it right now.
Okay. Any questions or thoughts, Elizabeth, you want to share about the infrastructure fund?
I'm fine with the infrastructure fund as it is.
Okay. All right. The next is a subject in which we have an expert in the room, so to speak, Elizabeth, and that is on page 10, the Universal Design Standards. And here, this is a study. We put it in the letter at 15,000. I think the major question was the number of people and whether you wanted to make it smaller, a little smaller, or the question is, the way it's written right now, it doesn't say may, it says shall be composed of the following members. So
I have a couple of things. First of all, first and foremost, I would really like to thank Maura Collins and Chad Simmons for their help on this, particularly Chad, who sent a draft of this to me.
Well, you should know both are in the room, so you better not say anything bad.
I didn't know they were in the room. Well, thank you both. And thank you both for working with me on this, even before the draft. I really appreciate this. And I should say, Chair Mahali, that the fact is that the reason for this is that there isn't somebody with expertise on this, and that's why we need a study for it. I went through and contemplate. Okay, one thing that I think needs to be added is the ability to have remote or hybrid meetings. And I don't believe it's in there, but
Let's see.
due to its nature, I think it's important.
Yeah.
What's that?
Meetings, I'm just looking, it's page 13 at the bottom, it's F, meetings. Let me just look. I think we'd want to add, we'd want to add that meetings may be by remote.
Or hybrid. Thanks to the nature of accessibility, I think it's important to make sure that the meetings are accessible to everybody.
Yeah.
So that's that. And then I was excuse me.
In the word.
What's that? What's that?
Somebody just was asking whether who was coming into the room, whether the coughing came from in the room, in which case I think they would have hightailed it, but
no, it's
you had the
I
consideration
apologize.
of appearing by Zoom.
I put check marks next to the following suggested members, and I these are just me, so I don't want to, I'd love for anybody objecting to these check marks, to please speak up. These check marks get the board down to 13 members. Ready?
The check marks are the ones you want to include,
Disinclude.
uninclude, the ones you want to disinvite.
Yep.
Right, got it. Who are they?
Line 10, the member appointed by Housing and Homelessness Alliance of Vermont. Line
Okay.
16, the member from LAOB. Line 17, an ARP member. Line
What was the
14.
second one?
I'm sorry. The second one is line 16, a member from the Land
12,
Access
it's item
Opportunity
number
Board.
12.
Line 17, a member from AARP.
Hold on. That is ARP, so that's item 13, yes.
Yes. Sorry. Item 14, DHCD. I don't know about
I don't know.
DHCD.
Yeah.
Why did I put that on there? I'm gonna put a dot next to that one instead.
Sorry.
Let's do.
Okay, ready?
Yeah.
Page 12, line 1, item 15, NeighborWorks of Western Vermont. Line 3, number 16, Vermont Mortgage Bankers Association. The next one, line 5,
Hold on. That is item number what?
16.
item number 16.
16. Yeah, okay.
Line 5, item 17, Vermont Bankers Association. Line 6, item 18, Association of Vermont Credit Unions. And line 8, item 19. Wait. No, sorry. That's what I've got right now. I
Okay.
crossed out removing VLCT.
One thought for you, Elizabeth, and the committee. I get that the reason this was such a broad list to begin with is this is a rather unique study group. It's not just designed to come up with some proposal about some subject or explore things in general. It's really it's a dual role. It's trying to educate people, get them feeling involved in the work. And so the original list was broad on purpose. On the other hand, you don't want a committee that's unwieldy. The committee always has the ability to seek out stakeholders and have them come and talk. And so I support reducing the size of the committee because I think I understand that in fact, the committee may want to seek out and talk to the people that were eliminated.
Yes.
Elizabeth, is that, so I would support that. How do people feel about those changes?
John?
Go ahead.
No. Did you, as in, like you're okay, or like maybe not?
I thought Tom was going.
Shaking his head, yes. You had a lot of nodding going on in the room, Elizabeth.
So you eliminated all of the mortgage, all of the lenders. I think, if I recall. Mortgage bankers, Vermont Bankers Association, Vermont Credit Unions.
Yeah, I did. Because
Is there someone else that can kind of listen for them? Because they're the ones that are gonna be asked to lend.
Yeah, but I also, when I was thinking about it,
The appraisers and assessors, are they the ones that really need to know because they're giving the information to the banks?
and they're on here.
They are, okay.
Yeah.
Is that, but I'm just saying, is that in your view, that's sufficient?
I
for the
think that's
information
sufficient.
that-
And
Okay.
because it's about making a standard, right? And when I really considered what would be a waste of time to ask people to do versus
Sit in
what would be a
meetings, yeah.
productive use of time, I thought that having lenders be involved in the actual creation of the standard might be a waste of their time.
I
Whereas,
think, yeah,
That's true.
whereas
Yep.
bringing them in at the end and having a meeting with them would be a more productive use of their time.
I
That was my
agree.
rationale.
I agree with you because I think that if the committee wants to talk to somebody, I mean, Chris Delia from, the Bankers Association would appear in a drop of a hat. But I don't know if he wants to sit through 6 meetings.
Right. Anyway, that was my rationale for better or worse. And so applying that same rationale, I asked myself whether each of these things, and what was the one that was DHCD, I do think should still remain. So that gives us 14 members.
So I'm just for,
Sorry,
go ahead.
you 14 members?
Yeah. I'm seeing, I want to just double check with the committee, including Elizabeth. So when we give instruction, we are omitting line 10 on page 11, number 9. We are omitting lines 16, 17, 12, items 12 and 13. On the next page, we are omitting lines 1, item 15, line 3, item 16, line 5, item 17, and line 6, 18.
I think the one that was up for question is DHCD, and I think I would like to see them on this committee.
Right.
Yeah, that was an accident.
Okay,
That was an accident.
I just wanted to make sure.
Where is the
Page 11.
Number 14, item 14.
Okay, let me ask, oh, but we're item number which?
14.
Okay, yeah, we did, okay. I do have one question. Holly, would you introduce yourself?
Sure, Holly Major, I'm the policy director for Vermont Housing and Conservation Board.
We are not having the board at all the meetings, is that okay?
Um,
Okay,
And I think we would work very closely with CHFA.
is anyone, how are people with this otherwise? With this study? Okay, I'm seeing nodding heads. Claudia?
Yes.
Okay.
And again, just to be absolutely sure, I'd really love to have hybrid or remote
Right,
meetings.
I added that.
All right, thank you.
My copy, and what I will do. I am assuming. Vice Chair and Magali, I am assuming that when we're done with this. We will give instructions to council to redraft for the next draft, right? Okay. So one thing we have to do today at the end of the day is make sure. I think the three of us have to get together and just make sure we have the right list, okay? Oh, the only other, what, yes?
More of a schedule for time.
Oh, okay.
Whenever.
Okay, well, I just have one other thing. Elizabeth. I have in my notes that on line 11 on page 14, it's not $200,000, it's $15,000. And I have on line 13, it would say for members of the committee who are not otherwise compensated.
Yes.
Okay. Now. Maura Collins is here to testify briefly, and my understanding is this is in response to all the comments, exasperations, and questions that were expressed yesterday on the issue of whether we should give them an added position to coordinate and study the whole issue of offsite housing And second of all, and the deadlines of February, of January, what is it? The deadlines, and finally, where in the world and how in the world are they really gonna spend $250,000? Which though one member of the committee referred to it as a drop in the bucket, another member of the committee referred to it as a lot of money.
I think I said a lot of money, even though it's a drop in the bucket in the budget.
Yeah,
I think that was,
you were this, it was the same member of the committee.
yeah, I think it was.
All right, so let's go to the page. It is
Page 30.
page 30, thank you. Okay, page 30. Maura, you want to introduce yourself and address in any way the issues that,
Happy to.
yeah,
So I'm Maura Collins. I'm the executive director of the Vermont Housing Finance Agency. And I think I'm in the waiting room to share my screen. I had just put they only sent Magali a memo about 20 minutes ago. So, but it is posted up on your website because she's that good. So what you will see here as I share my screen is going to be a very overwhelming memo. I think it's at 4 pages, so I'm not asking you to read it because it will be too small on the screen. But what I want to show you is
my goodness.
what considerations we're talking about. So what this says, when you do have a chance to read it at some point, is that Maura, in her own brain, but with no input from the other co-sponsors of the report that came out on offsite manufactured housing, started to make the list of the questions that will need to be answered through this study. So this 4-page list will grow when other smarter people share their opinions. But I went through the report that I'm sure you all read on offsite manufactured housing opportunities, and started to list the questions that need to be considered. And so the 2 things that I think the committee has grappled with is, 1, why do we need, I agree with you, so much money to study this issue? And 2, why can't it be done by November so that we could be considering this, you all could be considering the budget implications for next year? And the reason is because I think if this committee had enough time to everyone share what they think we're going to come out of with this report or our work, I think you would have vastly different ideas of what you're envisioning. I don't know how many of you want us to deeply look at multifamily housing. Does that mean for sale or rental? How many units are we going up to? Are we talking about ADUs? Are we talking about accessibility add-ons? There's manufactured offsite opportunities where you can just connect this unit onto the back of your house, and all of a sudden you have an accessible bathroom and bedroom, and there's a whole program there. Is that what we should be looking to explore? Because accessibility is our biggest priority in the state, and expanding home size. Or should we be looking at single family homes, and that's our priority? Or should we be looking at rentals? What types of construction are we talking about? What are the are we looking at prioritizing certain contractors for the site work? What, if I were to tell you we need X millions of dollars, does that include the installation? Every step? Is this the utility hookups? What would be included? Is our goal to have cheap housing, or is our goal to have a lot of housing? And is our goal to have time savings, because time is money? Do we prioritize in-state manufactured businesses? And so what is that going to take? Or are we okay if they come from New Hampshire or New York or Maine? And then should we look at opportunities that are eligible for other public funding, and these would be shared equity or middle income programs? Or are we looking at other things? How does energy efficiency fit into this? Should we be looking at design models? You want like a couple design options? Should we be really thinking about those that can handle solar or net zero, high energy, or not? Do we have to think about the environmental footprint? Sometimes these buildings can be not as good for the environment. Sometimes they can be great. And then also there's a recommendation to look at statewide building codes. There's already an effort underway. The Building Energy Code Working Group They released a report in November of 24, and their final report is due in November of 25. And one of their 3 charges is to consider whether or not the state should adopt a statewide building code. I don't want to be asked to do a study of the same thing that another study group is already asking, but I kind of want to wait for their answer before I can find out how that impacts off-site housing. And do we need a separate code for off-site? How do energy codes apply? We want to study the in-state experiences like the infill program and Tri-Park and people who've done bulk purchase. We also want to look at other states. That's going to take a minute. I don't know if Oregon's going to answer our call within 2 weeks when we call them up. If I think you want this to eventually develop a plan for the idea of bulk purchases. So all those earlier questions I just mentioned would have to be answered, but then are all the designs eligible? How are we going to pick them? What are these purchasing terms? Who determines the placement of the homes? Is it okay if I put them all into one park in Chittenden County? Something tells me no. So I'm going to have to think about geographic distribution and flood impacts and cost of installation, the cost of this program. How are these going to be financed? I'm assuming this is home ownership, but maybe it's rental. I got to think about Freddie and Fannie and saleable loans and these in communities with rented underlying loans. How are we selecting the residents? Is that, am I working with a nonprofit here who's going to do outreach and engagement, or is this on the free market? Can I take one of these homes and put it on my private land? Is there a homeless preference? Are we going to require financial counseling? If we're doing an RFI to find out from manufacturers in state or maybe out of state, what has to happen, that's going to take some time. The language right now says we're going to work with other New England states. Those conversations have begun. Don't know if they're going to answer my calls by November, which is, I think, the ideal timeline you were thinking of. Fairhaven plant has its own timeline. You heard they received a 60,000 state grant. I don't know when their report is due. I haven't talked to them. You should ask. I don't know that Mora should be able to, or VHFA should be able to put my finger on the scale to say that Fairhaven is the best solution for Vermont. It's the one we all talk about, and it's an existing one that we turn back on. So something tells me it's going to be pretty efficient. I don't know. There could be another plant opportunity in the Northeast Kingdom that I don't know about. And I think we would have to engage our PCs and our DCs to find out what's necessary. This business planning and support, I have talked to Vita about how to build out loans, grants, trade support, all this. And then you've talked about here the limited workforce. I don't know how that's going to impact our ability to roll out such a program. So that was overwhelming and fast. That was my way of saying, I cannot get you a report by November if it's going to be something that you're going to consider a major state investment of. It won't. I only bring you quality projects, and it won't be quality. So I can give you a progress report at various points every couple months, of how we're doing on this to do something smart. And this is risky. I want to be clear, a general contractor on our board, J.E. Morrissey, testified in Senate Housing, as well as Eric Hoekstra from Redstone Development, who both testified to say, people are foolish to think that offsite manufactured housing is always cheaper. They're very clear.
Our testimony indicates that's the case.
It's only when a program is designed well, and it has elements of maybe bulk purchase and all this, but thinking through, if I bulk purchase homes, where am I sticking those homes until we've identified the residents of those homes? What parcel of land? Where do I have to get them in the state? And I could just keep going. I can report on this progress regularly, but this is going to take, I don't know if 250,000 is the right number. So if you want to change it, feel free to change it. But I'm imagining some combination of in-house staffing to coordinate it and keep it moving, outside consultancy support, maybe some, I put in here at the beginning, sorry to make you dizzy, that may also mean like reimbursement for engagement. I mean, maybe for some focus groups or something, we'd have to buy lunch or do something. And that the money would support this, not all to come to VHFA. I can't answer half these questions. It would mean money for VITA, for the State Housing Authority to learn about their infill program, to our other partners, DHCD, maybe VHCB, I don't know, but to manage a budget and come up with a budget, which we can report on, to get this work done either through in-house staff that these entities have or through paid consultants, because honestly, we're already busy doing a lot of other things. And I'm gonna say, I do not see being able to propose to you a fully fleshed out plan by this fall or even January of next year, unless you all can tell me how to narrow this scope and you pick homeownership or rental, pick a couple communities, tell me like which type of construction model I have to follow, then all of a sudden I can probably get you something much sooner. But if I have to lead a public process for the state to determine at the funnel, I'm way up at the top wide part. If we got to get it down to here and then build a program once we've narrowed it, I need a year to narrow it and then a year to thoughtfully give you something that I hope would work.
I have a couple of questions for you. Despite my personal belief that you sitting alone in a room could come up with the answer to these questions in a day, I assume you are still comfortable with the preliminary on or before January 15th next year and the final on December 15th. And I assume you're still comfortable with the $250,000.
Yes.
And are telling us you could make it less, but I wouldn't recommend it if you want us to do all of it.
This is my best
Yeah, your best
estimate
shot.
at this point.
Okay, the question I have for you, since we're at the point where we need to draft, is, have you seen the text of what's in here?
Have we? Yes, it had the bullet points, right?
Yeah, no, the text of what's in here, the reason I say it is, but I believe it says Vermont Housing Financing Agency shall, and then it has 6
Bullet points, yeah.
bullet
Yep.
points. And those bullet points were part of our concern. They came, I think they were Ledge Council summary, or where did they come from?
They came from us.
Okay,
So that if you look at the headers of the memo I just had up, they do roughly mean the same things as those 6 bullet
so
points.
you're comfortable with the language because
Yes.
you originated it. Okay, my question is, I had, well, but it was mostly, no, I guess there was a certain amount of frustration. How do you feel about under number 2? Well, first of all, how do you feel including but not limited to language so that you can go beyond the 6 bullet points?
Yes, that would be.
Second of all, how do you feel about under number 2, rather than explore opportunities for using bulk purchases, it would be define the structure and relevant actors for using. Is that okay? And then the other was, instead of number 6, estimate, it would be prepare an analysis of.
Mhm.
Okay, other members of the, did you have a question?
Oh, I
Yeah.
just wanted to say that, I absolutely understand what you're saying and it makes sense. And I've been grateful for the work that your folks have done in the past for us is excellent quality work. And, I didn't get a chance to say yesterday, but this is really an important piece. A day doesn't go by in this building or constituents sending me articles being like, why aren't we doing this? So it's top of mind to the building, to constituents, to people all over the state. So I do think that this is a very important component and will be some really important work that we'll get back from you all. So just wanted to add that support to have that, but I understand the challenges and the timeline. So, but thank you.
Other questions of the committee?
I just want to say thank you for this presentation, Maura. I really appreciate it. That was sort of my thing, was just the what, right? And so this was really helpful to see that all laid out. And I hope that it can be consistent, because my issue with when we do these studies or these things like this, sometimes we come back and we're doing the same study again, and we're doing the same study again, and we're doing the same study again. And part of the conversation yesterday was, a lot of the information we have access to, but we don't know how to navigate and put that information in place. And so thank you for this illustration of how that will be done, the questions that will be answered, and the outcomes that we will get hopefully from this study. So now that I have a more clear picture of that, this is going to give us information that we don't, already have, it's going to enhance that information and how it's going to bolster that and supplement it and clarify the plan forward. I really appreciate that for my brain. So thank you for doing that. I really appreciate it.
You're welcome.
On this issue, the VHFA offsite construction report, is there other questions of Moira? I do have a couple of questions that don't relate directly to this. Are there questions about this? I might as well ask while we're here, with the changes that we discussed, is the committee comfortable with the study?
Mhm.
Heads nodding. All right. Yes?
Yes,
Okay.
yes. But real quick, one question, and this was my question from before that I'm going to circle back to, because we were talking about manufactured housing, and this is where my question comes in, is as we're having these conversations, which is not going to be about the bill. This is why. So I just want to table this. But when we're talking about manufactured housing and we're talking about this study and all of these things, and when you go back to the MER program, which is for mobile housing, is there going to be ever a conversation that incorporates other kinds of manufactured housing into other conversations, or is they always going to maintain that separation of manufactured housing as mobile homes and then manufactured housing as in offsite construct? Like that's been a barrier for me, and that's a table conversation for later, chair. But in the context of our housing plan and our housing committee bills, and as we're going forward, and for all of the folks, for conceptualization of manufactured housing, it's really confusing for my brain to separate the mobile home manufactured housing and then the offsite construction manufactured housing, and how can we blend that conversation to help merge our programming for the two separate things to increase our housing capacity. That's an offsite question that does need to be answered now, but I see, Maura, you look like you have a response.
I always do. I want to be clear with my language. What I'm proposing and what I'm imagining with this appropriation and study is that we are merging the two. When I use the term manufactured offsite, that's the big universe, and mobile homes is a subset of that. So what you're talking about and MER would be, I'd want to know the lessons learned. I want to know what else they need. I want to take from that. It also would include other opportunities that are not mobile homes, but my language is trying to bring the big universe where it is mobile homes and broader panelized construction together.
Thank you. While you're here, I would request, if you have a little time, that you remain, because, and also let you know, at 1:30 today, we're going to have here both Sean Gilpin and Alex Farrell to testify about VHIP. Their intention was to testify on a potential compromise on the 10-year program and taking out the language limiting it to helping people who are emerging from homelessness versus leaving that language in and seeking a compromise, and they have a proposal. That will be at 1:30. You may want to be here, or you may want someone to be here. I'm just letting you know that that's there. There have been at several places, both in mobile home parks and in VHIP, the question of whether we make sure that language allows loans and not just grants for private parties who might otherwise have to pay taxes on that. Does that seem acceptable to you, just to make sure that that option is there?
Yes.
And that's about it. I just wanted you to know about those. At this point, the next item, which we will be discussing, just for your information, is the first generation homebuyer program. And so you may want to remain for a few minutes for that, if you're able to.
If you can indulge me, I was planning on staying here up until your lunch break. At 1:00, I am in Commerce for at least an hour, but Chad will be here, so.
And I assume he's fully empowered to pretend to be you.
Chad is where the brains are. I just show up and sit in the chair.
Okay. So now what I'm going to do, if it's okay with everybody, I'm going to return to the order that we were in and making, I think, pretty good progress, working our way through this. We're now on page 15. What I'm doing, just so people know, is I'm putting check marks when we have talked about something as being, remember, nothing is decided till everything is decided. So, but I'm trying to tease out now issues, concerns, and see whether people are okay. And what I'm going to do is do this, the HFA. Then I want us, we've been in session since 9. I'd like to give us a break for 5 minutes. Yeah, 5 minutes, even though the boys' room is not available up here, but
I know.
yeah, it's really, something bad happened because of
It's
all.
the mezzanine's fault.
Is it? Yeah.
It was, yeah.
Yeah, that's what I heard. But first, let's do the VHFA First Generation Home Buyer and Down Payment Assistance Program. And I'm going to summarize, despite the fact that someone who could do a better job, two people who could do a better job are in the room. Since this is a committee discussion, I'm simply going to summarize what this particular version does is this allows the $250,000 tax credit per year. It extends it in such a way as to enable two separate programs. One is a first-time home buyer loan. And the second is a $10,000 grant for first-generation home buyer. That's what?
$15,000 grant.
15,000? Okay. And that $15,000 grant, in order to accomplish that, it's done in two separate sections. But the way it's written now is that the tax credit for first-time home buyers, excuse me, for first-time home buyers, wait a minute, is on page 18 at the top of the page, and it extends the $250,000 through fiscal year 2031. On page 17, under C, it allows those for the first generation without a deadline. Now, I'm not sure that's the way to write it, but that's the way it's in front of us right now. We can go through one more iteration to make sure it's done right. But I think the first thing that I'd like the committee, I'm not sure this is the best way to do it, to write it, but I just want to say, and I'm going to put it this way. When Maura testified, she said, look, we need to extend this program if you want us to continue to offer the first-time homebuyer program loan. But gee, I'd sure like to offer this $15,000 grant for first-generation homebuyers. And that's going to require no debt, you can't sunset in 2031. We need to go forward. This approach is intended to go with the more ambitious of the two options that Maura said. This approach is designed to do both. But it may not do it, but that was the intention. All right, Maura, get back here. You're being so expressive. We need to have you here.
I just need to make sure it's clear. These are two $250,000 tax credits.
Right.
Okay, so
it's 500,000.
it is. So that's what I need the committee to make sure they know, is that the 250,000 that we've had for a decade, we need 5 more years of, and that's why that one sunsets. And then that one can go away. But using that same tool for the first generation homebuyer grant program, you've been doing it through an appropriation. We're now using a tax credit model. So that will be a brand new $250,000 tax credit, and it's going to go on forever until you repeal the program.
Okay, so that would mean 500,000 a year for the first 5 years and then 250 after that.
Correct.
And you think the way it's written now, it does that?
Yes, that's why I get why it's confusing and it doesn't make sense, but if you understand them as two different things, that's why this 250 has to expire after 5 years.
Yeah.
And why this one goes on forever, and why they have to be separate is because they're separate 250. They just happen to be the same amount.
Okay. And I think what this committee needs to know is that, this is the more ambitious of the proposals. And that given that it's ambitious, where our letter, this wasn't affected at all in our letter to appropriations because it's not about an appropriation. It's a tax credit. Where it will make a difference is in the material that we submit to Ways and Means, which is where this will go. And I'm sure that Maura, that you will probably, or someone will testify about this in both Ways and Means. So how do people feel about this?
You know, it works. And it's helping. I support it.
I think there.
I will say, without the chart that you provided us showing the funding thing, just verbally, I would not understand this at all. So thank you for that.
Right.
Yeah, we were all worried that it was following one study with another study and that we wouldn't be any better off when it was done. But you have apparently reassured us.
No, this has nothing to do with that, actually.
No. I appreciate this program, and I just want to send a deeper appreciation because we have a conversation about pilots often, and we've heard for the past several weeks a conversation about funding and extending pilots. And I think this is an opportunity to really see something become self-sustainable over the course of 10 years, and we can see what that looks like in practicum. And that's what I like about this, is it sets a precedent and it provides an opportunity for us to actually see what could happen if we allowed something to continue in essentially perpetuity, but how it can actually become its own thing. Because my question when we hear things often is, when does a pilot not become a pilot anymore? And so when we keep extending it. And so that's what I really appreciate about this. And that vision and that ladder that you showed us was extremely helpful in explaining that.
Any other comments or questions on this issue? What I'm getting is a sense that people are, what I'm not hearing is anybody saying, no, I don't want to do this, or no, I just don't, I want to go on, I just want to fund for another 5 years the existing program, and I don't want to do the first time home buyers. I'm not hearing that. I'm hearing people are basically comfortable with its proposal. Am I right?
Correct.
Tom, you're pensive.
Well, I mean, 10 years from now, if the home market is entirely different, it can be revised then. But in this particular housing climate, I wouldn't take it out.
Okay, Debbie,
I'm satisfied with it.
Joe?
All right.
There's a movie I have to talk to you about sometime. Anyway, all right, so what I would like to do at this point is take a break, and what we will do,
Yes.
and let's just come back here at 11:15. That's 10 minutes.
That's a good break, yeah.
11, yeah, 10 minutes. And we will do the land bank report. Given, I think it's a practical matter, I'm going to pass over for now appeals. Given the testimony we heard, think about that, and I'm gonna pass over. So I think we might get through a first pass of this whole thing. Okay? We'll see.
I knew that. Yeah.